All right, welcome to Beverly Hills Bar Association's series on fundamentals of mergers, acquisitions, and restructuring of closely held businesses. I'm Bill Norman. I'm today representing the business law section, which developed through a planning committee a series of 4 separate webinars, one of which is today, and we'll introduce that in a moment. And in November 14th, just a couple of weeks from now, we'll have a program on tax aspects of buying, selling, and restructuring corporations with Stephen Mahaley and of KFB Rice and Megan Jones of Pillsbury. Then in the February, we'll have one on buying, selling, restructuring, and dividing partnership interests. Leighton Pace will be leading that. We'll have another speaker shortly on that. And then in March, we'll have a program on tax aspects of cross-border mergers, acquisitions, and restructuring. I'm going to do that with Alexander Lee of Cooley LLP. And that will then complete our series of 4 webinars. Today's program is on drafting of principal documents. It's kind of the foundation for everything. You can't really talk about tax till we know what the transaction is going to be. And we have Scott Ehrlich, who's has his team from Sklar Kirsh, who's going to present the program for us. Scott is the head of the Sklar Kirsh's merger and acquisition practice. His practice focuses on corporate M&A, finance transaction with emphasis on entertainment and media industry. He joined his current firm after serving 9 years as general counsel for Deluxe Entertainment Services Group, where he was the chief legal officer dealing in high-stake post-production, distribution technology deals, mergers, and acquisitions. With his team is going to be, or part of his team is going to be Jennifer Cohen. She's a corporate associate at Sklar Kirsh. She experienced in-house corporate counsel, and she was also an associate with a major law firm. Her clients include a wide range of industries, including media, entertainment, sports, and consumer products. And then also with the team is Ben Harrison, he's a corporate associate at Sklar Kirsh. His practices focuses on both private and public companies, a variety of industries, experience in counseling clients with respect to corporate law, mergers, acquisitions, joint ventures, and partnership dispute resolutions. More complete bios in the last page of the slide deck. I'll look at it at your leisure. And with that, I'll turn it over to Scott, who's going to then take us through the program.
Terrific. Thank you, Bill, and happy Halloween to everybody. One other shout out I want to make. I'm teaching this semester an adjunct professor at Loyola Law School. And I say that I want to give a shout out to my students who at least were invited to this. We'll see if they're here. I teach business planning and venture capital financing. Ben, Jenny, why don't you guys say a quick hello and then we'll get going.
Sure. Hi, everyone. I'm Jenny Cohen, corporate associate at Sklar Kirsh, and previously spent some time in-house and at a big law firm. Like Bill said, I'm looking forward to the presentation with everybody today.
Hi, everyone. I'm Ben Harrison, recently graduated from Loyola Law School, took the same class that Scott is teaching now, and I feel like my instruction has continued under very capable hands. So excited to present today.
Terrific. Thanks, guys. Okay, so Sklar Kirsh, just a quick piece to keep our marketing folks happy. We've got 4 practice areas at our firm: M&A, real estate, litigation, and bankruptcy and restructuring. We're 40 lawyers in Century City, and in the M&A practice, which is what we're going to talk about, our sweet spot are transactions between $10 and $350 million. And we probably do, this group, probably 2/3 of our practice is sell-side M&A. So before we get into the documentation, I thought I'd share at least our view of what the role of an M&A lawyer is. Really, we are project managers. We're quarterbacks for a team of lawyers and non-lawyers on a deal. There's investment bankers, CPAs, wealth advisors, internal CFOs, the client, of course, the owners and operators of the business. M&A lawyer is meant to coordinate all those different legal and non-legal players we need to be at least conversant in tax, employment, intellectual property, regulatory, antitrust aspects, without being experts in all those areas, but we need to be able to understand the issues and maybe more importantly, translate them to clients and synthesize them across all the different specialty areas. So that's the role, as I say, of an M&A lawyer. And as we get into the documentation, I like to tell clients that a purchase agreement is all about risk allocation. If you're a seller of a business, you really worry about two people who are trying to get their hands in your pockets. You've got the IRS, the tax authorities, who are looking to collect as much tax as possible on what is oftentimes a big liquidity event for the sellers. Obviously, you've got 3 more sessions in this program. Bill and tax lawyers like him will discuss the tax aspects, but that's a key part of structuring a transaction, is to minimize the tax exposure. And then really where the 3 of us earn our keep, there are, and we're going to go through it, representations and warranties, statements about the state of affairs of the business that's being sold, and a buyer will have rights to recover if any of those statements turn out to be untrue. If the business that the buyer buys is not in the condition the buyer thought it was, there is potential exposure from a seller. And I'll say to our seller clients, this sort of thing isn't any fun if you both sold the business to the buyer and then handed back to them all the money they paid you. So that representation, warranty, and indemnification, which we're going to get into, is a key role for an M&A lawyer. And on the buy side, it's the flip, which is to ensure that you're getting the benefit of the bargain. That if you bought particular assets or you bought a business with a particular state of affairs, you want to be sure you're getting exactly what it is you've paid for. So with that, let's get into what is going to be, call it a 90-minute high-level survey course on M&A. We're not going to be able to hit much of it in detail, but we're going to get across all the different key documents that go into an M&A transaction. Jenny?
Sure. So the first item we're going to go over is the NDA. This is key to ensuring that the information that the seller is disclosing to the buyer throughout the course of the M&A process is kept confidential. Many of you have probably seen NDAs before in your practice. So we're just going to hit some of the highlights that differentiates an M&A NDA in the merger and acquisition context. So the first is just taking a look at the scope of the NDA and making sure that the definition of confidential information is broad enough so that it covers the information that the seller is going to disclose in the course of the deal. And maybe if there's a particularly sensitive piece of information, you might want to call that out specifically. But general rule of thumb is to keep the definition broad if you're representing the seller. You also want to make sure that the NDA specifically states that the buyer can't use the information that's disclosed by the seller for any reason other than negotiating and considering the transaction. Another key term is the term of the NDA. Typically, we see these will range somewhere between 1 to 5 years, but it really depends on the deal. And with larger companies that have to keep track of many NDAs, they'll push for shorter terms. And then another item that we look for is to confirm that there's no legending requirement in the NDA. So a legending requirement would be if it says somewhere that in order for the information to be considered confidential and protected by the NDA, that it has to be labeled somewhere as confidential. We don't like these because, well, one, it puts an administrative burden on the seller to make sure that all the information they're either uploading to a data room or sending to the buyer is marked as confidential. And we don't want to, limit any information being covered by the NDA in that matter. Typically, when we're representing sellers, we'll serve up a one-way NDA, so it only protects the seller's information, usually because the seller is really the only one disclosing anything confidential. But sometimes buyers will come back and ask to make the NDA mutual. And in that case, we just want to make sure that you're not prohibiting the seller from kind of running a full sale process. So it needs to be clear in the NDA that the seller or its financial advisor, banker, whoever's running the process can go to bidders and say, bidder X bid this much or has this financial provision in their bid, and you need to come up with on your bid. NDAs can also include non-solicitation provisions. Sometimes usually there'll be a non-solicit for employees, and then sometimes they might also include a non-solicit for customers. For employee non-solicits, it's typically limited to employees that the buyer had contact with or was first introduced in connection with the transaction. And then there'll be a negotiation over different carve-outs. The typical one being that the buyer can continue to post general advertisements so long as they're not targeted at the target company and its employees. And then another thing to note is just if the buyer and seller are in the same industry and they're already competing, they might already be soliciting each other's employees or customers. And just to make sure, if you're representing the buyer or the seller, that you're watching out for these non-solicitation provisions. NDAs in the M&A context will also want to include some language saying that there's no obligation on the part of the seller to enter into any transaction just by virtue of the NDA. The seller is free to walk away at any time. And, there's no obligation to actually complete the sale until the transaction documents are entered into. This is goes along with a case known as SIGA, which Scott's going to talk about in the context of the LOI on the next slide. The NDA might also include a provision that says the buyer can't engage in joint bids. So this would be approaching another potential buyer in order to put forth a joint bid or a combined proposal for the seller. Sellers typically don't like this because it reduces the competition for the company, and so they'll include something in the NDA prohibiting it. There'll also be a no communications provision. And so this says that the potential buyer cannot communicate with anyone at the target, including their representatives, their employees, customers, or suppliers about the transaction. And this is because the seller wants to keep the transaction confidential and wants to manage the communication around the deal and doesn't want potential buyers digging around with their customers or potentially disclosing to employees that the company is being sold. They want to make sure that they have control over all those communications. Another key provision is making sure it's clear that the seller is not making any representations or warranties in the information that it's providing to the buyer. All the information is being provided as is, and no reps and warranties are being made other than what's actually negotiated in a transaction document if it's eventually entered into. And the last one is exceptions. So these NDAs will include a list of exceptions where the buyer is permitted to disclose information that it receives from the seller. So the usual list of this is the buyer can disclose information to its representatives who need to know that information in order to help the buyer consider the deal. Information that the buyer already knows or that the buyer receives from a third party that's not in breach of the NDA, that's usually fine to disclose. If the buyer independently develops any information by itself, or if the information becomes generally known to the public, those are usually exceptions as well. And then last would be any information that has to be disclosed because it's required by law. So just a practice pointer on negotiating NDAs. This is usually one of the first steps in the transaction. And, we like to negotiate them to make sure we're protecting our client, but making sure that we don't over-negotiate the NDA. A lot of times, people don't tolerate over-lawyering this document. And so just making sure that you're keeping as light a touch as possible while also protecting the client is key in our view.
Right. So maybe let me bridge what Jenny was saying about NDAs and letter of intent, which is the next stage of this. Both of these documents, clients often feel very comfortable, whether they're actually comfortable or they don't know any better, to negotiate without lawyers. To the extent you can whisper to your client or involve yourself, we think it's important. You've heard some of the nuances on NDAs. I'm going to hit some of the nuances on a letter of intent, particularly, as Jenny said, for businesses that are already competing with each other. There are some nuances and things to trip up if you're not careful. in a letter of intent, and just to hit some of the lingo that you'll hear people use, letter of intent, term sheet, MOU, memorandum of understanding are all synonyms for each other. And there's a whole area of the law to think about. When people sign a letter of intent, it looks and it feels like a contract. It's words on a page, to be basic about it, and it's usually signed, and that has the feel of a contract. But most of the time, we mean for these to be non-binding. We mean for them to be, call it a memory aid, or maybe there's agreement, but only on the headline terms of, I'll buy your business for this price. But that comes with a whole lot of assumptions. We need to review things at the business. Maybe we need to line up our financing. But the point of it, a letter of intent, is to say we have enough comfort with each other at the moment to proceed, to spend a lot of money with lawyers and accountants and to proceed, but we're not at the moment committed to do a deal. So most of the time, letters of intent are meant to be non-binding, with some exceptions that I'll hit in a moment. The reason you see SIGA up on the slide, and Jenny mentioned it in the non-disclosure area, is this is a case from a few years ago. And while for the litigators in the crowd, this is a case about expectation damages, that's not how it plays out for M&A lawyers. This was a case involving a non-binding term sheet, but within the non-binding term sheet language was a covenant to negotiate in good faith. And I think I would say most of the M&A practitioners understand that a non-binding letter of intent is, as I say earlier, a conversation piece or a memory aid, or at least an understanding that we sort of have a deal, but we're still negotiating. And a key part of negotiating is the ability to get up and walk away from the table. I'm not saying you do that every minute. This group understands how to negotiate, and you need to have some credibility in your negotiations, but ultimately you may not reach a deal and you need to have the freedom to get up and walk away from the table. The SIGA case found that the covenant of good faith, to negotiate in good faith rather, was itself a binding covenant. So notwithstanding the non-binding nature of the term sheet, by including a good faith covenant, the party found themselves unable to get up from the table, as I say, and was held to be in breach of what they thought was a non-binding term sheet. So you'll see practitioners, the practice now is to go out of your way and say, neither side owes the other a duty to proceed. The deal may or may not go on, and again, all to retain that ability to continue negotiating. Letter of intent is early days, and it's still viewed as the courting stage. And I say that so that the seller still has the best leverage. Hopefully, the seller's in a position where there's multiple bidders, or at least one bidder that's very keen to do the deal. And so it's a place for the sellers to call out things that are important to them. And most important to the seller, I mentioned it earlier, when I said it was somebody's hand could be in your pocket later, is to spell out the indemnification package, what your exposure as a seller is going to be. We're going to get into details later, but the point is, as a timing matter, now is the time at the letter of intent stage to outline the indemnification package. Exclusivity or no shop. This is the key provision for a buyer. Buyer wants to know that we have enough of a deal that the seller is no longer shopping their business around to multiple bidders. They're not taking the buyer's offer and shopping it around to others to see if they'll beat it. In order for everyone to spend all the time and money into this, the buyer's going to want to know they have exclusivity. And so that's a binding provision. So these letters, when you read them, are a mix. Most of the provisions are expressly non-binding. Some of the provisions, exclusivity, no shop, maybe a confidentiality section if there's not a standalone NDA, are going to be binding. That's critical for the M&A lawyer to understand exactly which sections are meant to be binding, which are meant to be non-binding. Again, because you're early days at a courting stage, if it's important to have employment arrangements spelled out, and I don't mean an employment agreement, but if the seller expects to be employed, or if the buyer believes it necessary for the seller to be employed as part of the deal. That should be spelled out. Gross up is a tax concept we're going to leave to the tax lawyers on the next 3 sections, but depending on how a deal is structured, there's some tax structuring and some tax equalization to be done. And again, this is the time to spell that out. And lastly is what sort of purchase price adjustments, if any. Again, this is a flavor of what the purchase price looks like. There shouldn't be any surprises on the headline purchase price. This is the time to do it. And I think, as I said at the top of the slide, with all of that, we think it's important for lawyers to be involved at the letter of intent stage, and we certainly encourage it to happen that way. And sorry, I see there was a question. I think I hit it right. There's synonyms between LOI, MOU. They're all flavors of what people think are short form agreements. But if we all remember back to Contracts 101, a contract is any sort of agreement you've reached either with a signed document or a handshake or whatever. But again, I hit the synonyms, term sheet, LOI, MOU.
Great. So after the LOI is signed, due diligence really kicks off in earnest. And the purpose of due diligence from the buyer's perspective is to confirm the state of affairs of the business that they're looking to buy. So is the business, does it have all the assets that the buyer expects to buy? And is the business consistent with the business that the buyer thinks that they're purchasing and the valuation that they attributed to the business? So the buyer will spend time reviewing the seller's ownership of the assets. They want to make sure that the seller actually owns the assets they say they own. There's also a review of any third-party consents that are required in order to complete the transaction. This is really important because third-party consents can take time to go out and obtain. And the third party is not necessarily motivated, to close a deal like a buyer and a seller would be. So the buyer wants to know at the beginning of the process what consents are going to be required, how long it might take to get them, if they're going to be able to get them, etc. So some of the third-party consents that we often see are if the target has a lease, they would have to go out and get the landlord consent to transfer that lease to the buyer. If there's any debt at the target company, the lender's consent might be required. But there could potentially be consents required from key customers or key suppliers. And then also another thing that the buyer is looking for is if the transaction is going to trigger any agreements that the target has with their employees or any equity arrangements that are outstanding and kind of what those will look like in the context of the transaction. The buyer will also engage in contract review to understand the universe of contracts that the target's entered into. If there's a regulatory aspect to the deal and the target's in a regulated industry, there could be regulatory review as well, data privacy review, kind of all other areas, that is applicable to the target's business. The buyer will also want to make sure that they've confirmed the seller has authority to actually enter into the transaction. So for example, if the seller is a corporation, is stockholder consent required, is board consent required, and is the target actually going to be able to go out and get those consents to complete the transaction? And one of the key things to remember about the due diligence process is although a lot of information is flowing back and forth between the buyer and the seller, none of the information that's disclosed by the seller in the course of due diligence actually counts towards the disclosures required by the representations and warranties in the transaction document. It's all for informational purposes, and the seller still needs to put all of the disclosures that are responsive to the representations and warranties in the transaction agreement itself, either in the body of the agreement or in the disclosure schedules. And we'll talk more about disclosure schedules later on, but that's always a key thing that surprises people, that disclosure doesn't mean putting something in a data room or sending it to a buyer by email. It means putting it on the disclosure schedules in the transaction document.
So representations and warranties, we're now talking about the purchase agreement itself. We've gotten past the NDA, the letter of intent. It seems the parties have a deal and they're proceeding, and these purchase agreements are 50 or 60 pages long. And the bulk of the reason that they are that long is there are representations and warranties made by the seller describing the state of affairs of the business. Things like there's no litigation. All of our employees are properly authorized to work in the United States. Everyone's classified appropriately as an employee or an independent contractor. The financial statements are accurate. Those sorts of statements, and as I say, this is probably of the 50 or 60 pages, probably 30 pages are all of the statements that a seller makes about the business. This is a key part of the buyer's reason to do the deal, or to say it differently, they're relying on all of these representations and warranties to tell them about the state of affairs of the business that they're buying. Jenny mentioned due diligence. The representations and warranties themselves serve a due diligence purpose. They also serve a purpose for closing conditions. They need to be true and correct at closing. And lastly, they would serve, if something proves to be untrue, as a source of recovery for the buyer. So to get into it, there are two flavors of representations and warranties. Before I get into that, understand that as a general matter, the buyer and seller will negotiate for their own negotiated statute of limitations for when claims can be brought, generally 18 or 24 months. They'll negotiate for the maximum exposure, a cap on liability, maybe 10% of the purchase price, and they'll negotiate for a deductible, just like in your insurance, your car insurance or homeowner's insurance. You know, don't bother me with a $5,000 claim. The claim needs to be at least $50,000 or something. So that's the general rules. So the distinction between fundamental and non-fundamental is important because the category of fundamental representations, like the name suggests, are so fundamental that they're not subject to those parameters I was just talking about. A breach of a fundamental representation is not subject to the survival period or the negotiated statute of limitations. It's not subject to the cap, not subject to the deductible. The types of things that fit into the fundamental representations are usually very limited. The capitalization of the seller's authority to do the deal, the seller was duly incorporated. If you're buying assets, that the seller has title to the assets it's selling you. I mean, that's about as fundamental as you can get. If you're buying stock, the sellers have title to the stock that they're selling you. So those sorts of basic representations are viewed as so fundamental to the deal that they're accepted from the negotiated limits on liability. Knowledge and materiality. This is a big part of the lawyer's day, is to try to soften some of the representations. So I said one example would be a representation of no litigation. Well, maybe the lawyer for the seller is going to soften it and say no material litigation, or to our knowledge, all the employees are lawful in America. But you can see how this is a negotiated section, and sometimes the seller is able to get qualifiers like that to soften the representations, and sometimes not. Much of what you'll hear M&A lawyers talk about is we're simply allocating risk. In other words, it doesn't necessarily matter if the seller knows or should know the truthfulness of the statement. The buyer may or may not be sympathetic to a knowledge qualifier. Again, you'll hear the buyer saying, it doesn't matter if you know it or you don't. We're simply allocating the risk. If there's a problem, it's with you. When we try to ring fence on the seller side, what we mean here is that there are any number of specifically negotiated representations, for example, tax. And again, the tax team that's going to speak for the next 3 sessions is heavily involved in negotiating a tax representation. The company's paid its taxes, etc. Having negotiated 2 or 3 pages of a tax representation, we would say as the seller's counsel, that's the universe of claims for a tax claim. There's usually a separate representation, just a generic, the seller's complied with all laws. That could pick up, and frankly does pick up, compliance with tax laws. We try to ring fence and say that compliance with laws rep does not apply to taxes, see the tax representation. We've just negotiated it. Sometimes you win on that point, sometimes you don't. The next 3 points all travel together. We've all seen entire agreements or entire agreements provisions at the end of every commercial contract. In the M&A world, entire agreement provision absolutely exists, but it's not sufficient on its own. The fight here and what a seller's lawyer is trying to protect against are claims of other representations that maybe were made over cocktails or in other discussions. And over time, what you've seen is buyers bring claims alleging fraud, alleging tort actions in what is really what M&A lawyers think of as a contract claim. We've negotiated a contract, and any claims you want to bring ought to be contract claims. But over time, buyers have brought fraud or tort claims, and the case law says that an entire agreements provision is not alone sufficient. If you want to protect against claims that somebody made representations elsewhere, or that a buyer relied on other representations. So in order to, again, help put parameters around this, it's important to have a statement that there's no other representations and that the buyer did not rely on any representations. Key element of a fraud claim is reliance. So by putting in a statement that the buyer is not relying on any other statements helps to defeat a fraud claim. This is, again, all aimed at, once we've negotiated the universe of representations and warranties, what the parameters around survival and a cap, a maximum exposure, and a deductible, you wouldn't want the buyer to be able to go around those rules and bring claims in excess of those amounts.
Right. So next up, talk about covenants between signing and closing. Essentially, these are provisions in a purchase agreement. One of the parties will take some action or refrain from taking some action between signing and closing. And so, as the name sort of denotes, these come into play in a deal with a delayed closing, where there is not a simultaneous sign and close. A classic non-M&A example is buying a home. You sign the sale contract, but you don't necessarily move in the same day. Different things have to occur: financing, inspection. All of that takes place before you move in. And similar activities occur between signing and closing in the M&A context, especially in public company deals, such as stockholder approval, like we saw in this recent Twitter deal, potentially arranging financing or regulatory approvals. Something to note sort of on the front end of this, M&A attorneys are in large part in the business of providing deal certainty, ensuring that the deal is going to close, consideration will be exchanged, and everyone sort of rides into the sunset. Any delay between signing and closing introduces uncertainty into that equation. So a good example of that is this recent Twitter deal that closed on Friday between Twitter and Elon Musk. It was signed back in April, I believe, and it just closed on Friday, 6 months later. As anyone who has followed it knows, there's an incredible amount of uncertainty during that period as to whether the deal would actually close. In private companies, there's reasons to have a delayed closing, but most of our deals are simultaneous sign and close, and that introduces minimal uncertainty. So sort of going down some common pre-closing covenants. Satisfying closing conditions is one of them. As Jenny talked about a little earlier, there's third-party consents that need to be gotten or obtained, and to the extent they haven't already been obtained before signing. So that's landlords, lenders, material contracts with customers and suppliers, key employees. Another closing condition would be shareholder approval, especially in public company deals. Another one is regulatory approvals, such as Hart-Scott-Rodino Antitrust Act. So, like a few different issues in the M&A space, this is an issue that needs to be addressed alongside competent antitrust counsel. But for us M&A lawyers, the most important thing to remember is the size of the transaction tests, which requires HSR reporting if the value of the transaction, the equity or the assets to be acquired, exceeds 101 million. So that does change every year. So you'll need to Google it essentially, or keep in mind whatever the number is for the year to know whether your transaction is going to trigger a reporting requirement under Hart-Scott-Rodino. Another covenant involves what's called a drop dead date. This is a termination provision that states that either party can terminate the transaction if it hasn't closed by a certain date. This helps to keep both parties' noses to the grindstone and, you know, push everyone towards the finish line and get the deal closed. Sellers don't want to be locked into a negotiation forever. Buyers want to take their money elsewhere if the deal isn't closing, and it sort of prevents either party from sitting on their hands and running out the clock. And sort of what goes hand in hand with that is a separate covenant to work towards accomplishing the closing conditions. You know, that goes for any of these closing conditions that we've discussed. The drop dead date provision usually requires, in a sense, clean hands, in that a party can only terminate, take advantage of that termination provision if they have been actively working towards accomplishing the closing condition. Another common one is interim operating covenants, and that's meant to keep the seller's business operating in generally the same manner during the period between signing and closing, with no big material changes in the nature of the business. That ensures that the buyer gets the benefit of the bargain. The company that they negotiated for, they want that to be the company they are taking possession of upon closing. Finally, a common covenant is a no-shop, which prevents the seller from engaging in negotiations with any competing acquirers, gives the present buyer exclusivity and sort of incentivizes both of them to pursue the transaction and move towards closing.
And I just want to add one thing for the group, which is in the private company space where we're in, as a lawyer, you should come in with a premise that we're going to sign and close simultaneously. You should then have someone convince you, or obviously convince yourself, what it is needs to be done that can't be accomplished and requires a delay between signing and closing. But you should be working very, very hard to sign and close to eliminate any of the uncertainty that Ben mentioned. If it turns out there's something to be done and you're convinced of something to be done, then obviously you have to address it, HSR timing, for example. But your operating premise should be, we're here to sign and close right away.
Okay, so the indemnification provision, this is one of the key efforts for an M&A lawyer when negotiating the purchase agreement. And that's because this is where a buyer gets its remedy if a seller breaches a representation warranty or a covenant in the purchase agreement, and it's really where seller's exposure in the deal lies. So basically, this is meant to negotiate and kind of change what would otherwise be a breach of contract claim that the buyer would have if the seller breached. And it turns it into more of a negotiated path for a remedy that the parties have actually set forth in the agreement itself. So the first item in the indemnification section we'll talk about is the basket. This is basically like a deductible on an insurance policy. Scott mentioned it earlier. It's the amount of losses that the buyer has to bear until it can start recovering from the seller. Usually the basket's set around 0.5% to 1% of the purchase price in deals. And along with the basket, we typically see a cap. So this is the seller's maximum exposure for any breaches of representations and warranties. For the fundamental representations and warranties, those may be uncapped, or there could be a cap at the purchase price. And for the non-fundamental representations and warranties, it's typically capped at around 10% of the purchase price. And then the parties will also negotiate a survival period. As Scott mentioned, this functions like a statute of limitations on when the buyer can bring a claim for a breach of rep and warranty. So for the non-fundamental business reps and warranties, typically that ranges from anywhere from 12 to 24 months. And for fundamental reps, it can be up around 6 years typically. And just one note that all of these limitations, the basket, the cap, the survival period, These are negotiated limitations on breaches of representations and warranties, but they don't apply to breaches of covenants in the agreement. So for example, if there's a non-compete and the seller is not permitted to compete with the buyer after the closing, but the seller breaches the non-compete, that's not going to be limited by a basket or a cap. The buyer is going to be able to recover for the full amount of damage. And it won't be limited by, say, an 18-month survival period. It extends until the term of the non-compete.
So, sorry, Jenny, I just want to emphasize that's a key practice point. We see regularly people mess that up. There's no other way to say it, where buyers agree to limits on covenants when they really shouldn't. The non-compete's the classic example for that. 12-month survival on a 5-year non-compete doesn't make sense, but we see it fairly often. You need to be very precise in the drafting. These caps, baskets, and survivals apply only to the rep and warranty, as Jenny said, and not the covenants.
So another thing that will typically be carved out of the limitations is fraud. If the seller has engaged in any fraud or criminal misconduct, that's not going to be limited by a cap or a basket, for example. And these days, people are actually specifically negotiating the definition of fraud that's in the purchase agreement to make it more of an intentional standard. It's not just the lowercase fraud anymore, but there's actually a defined term fraud, and that can be the subject of a negotiation. The indemnification provision may include a sandbagging provision as well. So sandbagging refers to a situation where the buyer knows that the seller can't make a rep and warranty or is in breach of a representation, but they go ahead and close the deal, and then after the closing, turn around and look to the seller for indemnification because there's a breach. So obviously sellers are resistant to these types of provisions. They'll actually ask to include the opposite language, that the buyer cannot claim a breach if they knew about a breach ahead of time. But these days, usually purchase agreements are silent on sandbagging. So you may not see that in the agreement. The indemnification provision will also, it may include a materiality scrape. So this is where the parties agree that even though there's a bunch of materiality qualifiers throughout the representations and warranties that Scott explained that lawyers spend a lot of time negotiating, for purposes of determining if there's any breach or if there's any loss in the indemnification section, the parties are going to disregard those materiality qualifiers. So if there's a breach, then it's a breach. It doesn't matter if the litigation is material, for example, in the example that Scott gave. So the argument for materiality scrapes is that there's already a basket, usually, that the parties have negotiated that's supposed to kind of set the threshold for what's a material breach and what's a material loss already. And so if you also have a materiality qualifier in the reps and warranties, and the buyer has to prove both that the breach is material and has to wait for the basket to be met in order to recover, that's really a double materiality standard. And so there should be a materiality scrape if there's already a basket. The indemnification section could also include a holdback or an escrow. Most commonly we see an escrow, and that could be for a portion of the purchase price that the parties have negotiated in advance. And how that works is the buyer will deposit a portion of the purchase price into an escrow account. And if any indemnification claims arise within a certain period of time, those claims would be paid to the buyer first out of the escrow account. And then, once whatever period of time is that the parties have negotiated, the escrow is released and anything that remains goes back to the seller. There may also, if this is a rep and warranty insurance deal, which Ben's going to talk about later on, there could be a smaller escrow just for the retention under the rep and warranty insurance policy that's held back as well. And then in addition to the indemnification provisions for, or the rights to indemnification for representation and warranty breaches or for covenant breaches, there could be specific indemnities that are negotiated, and these are going to be specific to each M&A deal. So for example, if there's a material piece of litigation or something that's come up in diligence that the buyer is really concerned about, the parties could include a specific indemnity to cover any losses that come out of that particular issue that the seller is going to have to bear the risk of. And then last, usually there's a set-off provision in these indemnification sections. So This really comes up or is most applicable when there's some kind of deferred purchase price. So the buyer is going to pay a purchase price at the closing, and then there'll be additional payments made, following the closing after some period of time. And the set-off provision will say that if there's an indemnification claim and the buyer is entitled to indemnification from the seller, the buyer can just offset any amounts that it's owed from the seller by deducting it from that deferred compensation or deferred payment. And that kind of gives the buyer the right to self-help and ensure that they'll get paid for their indemnification.
Jenny, let me hit one thing, and then there's two questions if you can see them, if you want to take them, but let me just hit one thing. I realize there's a basic point here that isn't covered in our slides. If you're familiar with the American rule, you know that in the US for litigation, people cover their own legal fees as opposed to England and other countries. And so for this indemnification, this includes legal fees. The definition of what a loss is, if a buyer brings a claim, includes attorney's fees. And as a drafting point, given the American rule and courts disfavoring prevailing party getting their attorney's fees, you need to be very precise that you mean both in the situation of a direct claim between the parties and coverage for a third party claim. But the short soundbite is losses include attorney's fees for both direct and third party claims. That's part of indemnifications to pick up prevailing party legal fees. Jenny, if you can see these questions, do you want to take them or do you want me to?
Sure, yeah. So one of the questions is, what are the guidelines for determining the cap in the basket? So the basket is usually around 0.5% to 1% of the purchase price. And the cap for non-fundamental representations is typically around 10% of the purchase price. And for fundamental representations, it's either uncapped or there could be a cap at the full amount of the purchase price. And then another question is what is sandbagging? So this is when there's a provision in the agreement that says it doesn't matter if the buyer knows that the seller is in breach of a representation or warranty at the closing. The seller can still turn around, the buyer can still turn around after the closing occurs and pursue a claim for indemnification against the seller because they breached a representation. And so that's a very pro-buyer provision. The opposite would be an anti-sandbagging provision, which sellers would prefer to include, which says that if the buyer knows about a breach at the close, prior to the closing or at the closing, then the buyer can't turn around and claim a breach and seek indemnification for that same breach after the closing.
Let me just add one thing for the group. I think it's the rare buyer who says to herself, I know some information. I know that the representation the seller is making is untrue. I'm going to close and then I'm going to bring a claim for breach of representation because I know they're wrong. I think I think you've got to be very not only aggressive to do that, you've got to be lucky, I think, to win that case. I think this comes up, and the reason people draft for it is, I think in the real world, it's not as black and white as my example. I think the risk is a buyer brings a claim and the seller's first defense is, what do you mean you're bringing that claim? You knew about this problem. And so the sandbagging language is meant to sort of pick a side and help color that more real world example. As I say, I think certainly as a lawyer, you would not counsel your client, great news, hold that information, we'll close based on a clean representation, and then we'll bring a claim later, even though we knew about this before we closed. But that's sandbagging, is holding information, knowing the representation is untrue.
Great. So next, I'll talk about sort of something of an alternative to the traditional indemnification package that Jenny talked about. It's representations and warranties insurance. A lot of times it's called RWI. So it's essentially a commercial insurance policy purchased from a third-party provider, and it provides coverage for breaches of reps and warranties rather than setting aside a portion of the purchase price in escrow. And so use cases, generally transactions 25 million and above, but it's become fairly ubiquitous. A lot of deal term studies put it at least 50% of deals that they're surveying, they see it. Although this is probably higher in reality, since buyers don't always disclose a buy side RWI policy. And it's in, essentially every deal that we see. So a lot of benefits. It allows the seller and selling stockholders, especially, to just close the deal and move on with their life without being sort of worried about, long tail claims or anything, and being liable far into the future. Inclusion of an RWI policy can make a buyer's bid stronger. It doesn't require a holdback or escrow, generally, at least not in the size of a traditional indemnification package. There's simplified negotiations. There's no, Jenny talked about materiality and knowledge qualifiers. You don't have to negotiate those terms with an RWI policy. And then a longer survival period. Typical RWI policy survives for 3 years, and then the tax reps for 6 years, as opposed to, what's generally negotiated to be a 12 to 18 month survival period for reps and warranties in deals that lack an insurance policy. So like anything else, there's trade-offs. There are some limitations. RWI policies only cover reps and warranties, as is in the name. Specific indemnities generally aren't covered. Specific covenants, like the non-compete and transition services and some of the other points I hit earlier. Known items, items that are disclosed or known to buyers, sort of getting back to that sandbagging point, also not covered. So there are some limitations. One of the points that gets negotiated is who pays for the premium. So it's, I guess, just to note quickly, the vast majority of deals, they feature a buy-side policy, regardless of who's paying the premium, that indemnifies the buyer for covered losses resulting from breach of reps and warranties. So anyways, who pays the premium? In an auction situation where there's multiple buyers sort of vying for the top position and trying to make their bid as attractive as possible, typically all of them are going to offer to pay the 100% of the premium as a price of admission, essentially, to the auction. It's a small price to pay to be competitive with the other buyers that are involved. Sometimes the seller will offer to pay the premium, and then oftentimes it's split 50-50 between the buyer and the seller. So to illustrate this a little better, I'll kind of give some values for sort of the different pricing points that get negotiated, and all of them are up to negotiation. The policy as a whole, it covers, typically it's up 10 to 20% of the purchase price. So if you're talking about a $50 million transaction, 20% coverage would be 10 million. The premium is going to be approximately 3% of the coverage amount. The retention, or the deductible, essentially, is approximately 1% of the purchase price. And then on top of that, there's typically an underwriting fee. So yeah, we talked about how sort of this is an alternative to a traditional indemnification package, but there is sometimes a escrow for the deductible. The seller's portion will be taken from the purchase price and put into escrow. And I mentioned that there is a underwriting fee for obtaining an RWI policy. A buy-side diligence memo is required, and generally this doesn't add a lot of time and expense to the entire endeavor. The buyer counsel is doing due diligence already. They already have a data room set up with third-party diligence reports and quality of earnings. This has become common enough where underwriting is pretty fast. I think it's around 7 days. And let's see. So fundamental and non-fundamental reps. In some deals, the RWI policy is the sole recourse for non-fundamental reps. And it's for fundamental reps, the RWI policy is typically the first source of recovery, with sellers sometimes backstopping the policy. So walkaway deal, this sort of implies when the RWI policy is the sole recourse, seller stockholders can walk away after closing without worrying about future liability, sort of getting back to that, certainty, walk away into the sunset sort of end result that we're looking for. And I think I hit this earlier, but it doesn't extend to breaches of covenants or specified or standalone indemnities. It replaces that traditional indemnification package, but only for breaches of reps and warranties. Like if seller breaches the non-compete or any of the other covenants, RWI won't cover it.
Thanks, Ben. Let me try and hit this question just while we're here on rep and warranty insurance. And before I hit the question, just Ben hit it, but I want to make sure the group, again, as a practice point, gets it. There are two flavors of insurance, buy side and sell side. Buy side is better. I'll let the insurance underwriters tell you why that's the case. The point for this group to remember is that buy side is better, and it's not dependent on who pays. So even if you negotiate that the seller is the one paying for the policy, you can still get, and you should get, a buy side policy. Sometimes people get confused and they think if a seller's buying it, it needs to be a sell side. It's not. Just remember, you want the better policy, and then you can negotiate who's paying for that better policy. To the question of are there provisions that make insurance easier or more difficult, I describe it a little differently. I think it's the facts on the ground. So generally, the target company needs to be sophisticated enough, maybe not audited financials, but financials good enough for a quality of earnings to take place. Records in good shape. The reason we say 25 million and above as a deal price is because the pricing, I know Ben went through it quickly, but the math, you really struggle with the math to pay for a premium on a deal that's smaller than that. But 25 million and above, we see it. And then it becomes a question of, is the company sophisticated enough to get through the diligence that the underwriter is going to require? I think we've seen it. We have not seen it. Let me put it this way. We have not seen a deal where we could not get coverage. The other thing that was interesting, if you remember, at the end of 2021, where M&A was off the charts, there was a fear that the Biden administration was going to put in place new tax rules at the beginning of 2022. It didn't pan out, but at the end of 21, there was a great rush to get M&A deals done, and the underwriters were frankly overwhelmed. So if your deal, capitalism at work, if your deal was not large enough to provide a sufficient fee to the underwriters, they were simply not going to spend time on your deal. So there was a tremendous rush to get deals done and a tremendous fight to get in the queue to get the underwriters to pay attention to you. Ben also mentioned it briefly. The phrase is you can't sandbag the insurance carrier, meaning they will not insure for known problems. So there will be likely a number of exclusions to the policy. So the buyer needs to think about, are there so many exclusions in the policy that the policy is now suddenly not worthwhile? You address those exclusions back in the traditional fashion. You'll put an escrow in place. You'll get a specific indemnity, but the point is you won't be getting it from the insurance carrier, any known problem. So hopefully that answers the question.
Great.
Okay, so the disclosure schedules, this is a document that supplements the representations and warranties that are actually in the purchase agreement. And there's two types of disclosures that go on the disclosure schedules. It's exceptions to the representations and warranties. So for example, if there's a representation that there's no litigation outstanding against the target company, but the target, is a subject of a litigation, then you would disclose the litigation on the schedule as an exception. And then some of the representations and warranties call for additional information that go on the schedule. So for example, the buyer might want to know or have a list of all employees at the company. And the employee representation would say, set forth on this section of the disclosure schedule is a list of all employees. And then the seller would have to list those employees on the schedule. Again, as I mentioned before, the key to the disclosure schedules is actually writing the information onto the schedule. It's a process that goes along with negotiating the representations and warranties. As the reps change, the schedules also have to change to reflect the appropriate disclosures. But to the extent information is provided in a data room or exchanged via email or through the bankers, that doesn't count as a disclosure on the schedules. It actually has to be written and described on the schedules. When representing the seller, the typical rule of thumb is that the more the merrier. You want to include disclosures so that you can say to the buyer, if there's ever an issue after the closing, look, I told you about this ahead of time, it's disclosed on the schedule, and there's no indemnification required for items that have been disclosed. And so in that respect, it's kind of like the seller being able to write their own insurance policy. The more information on the schedules generally, the better that they can point to after the fact. It's important never to hide or bury any negative information on the schedule. You always want to be upfront about the information that you're disclosing. Usually it's kind of seen as bad form to disclose things or anything that's material for the first time on a schedule. It would usually be discussed among the parties first or disclosed in the data room so that the buyer is well aware of the negative information. And then, it would also show up on the schedule, but it's not a surprise to the buyer. When disclosing, even though there could be materiality qualifiers throughout the representations and warranties, when we're advising sellers, we tell them to disclose without regard to those materiality qualifiers. And that's because of the materiality scrape that I described earlier. Many times for purposes of determining if there's a breach or any loss, those materiality qualifiers are going to be read out of the agreement. And so it's better for the seller to put anything that could be responsive to the representation, whether or not it's material, on the schedule. And then sometimes there could be, like was mentioned earlier, we like to sign and close concurrently. But if there is a delayed sign and close, there's always a question of whether the disclosure schedules are going to be updated between the signing and the closing. And this is because the seller is going to have to make all the reps and warranties that it's making at the signing again at the closing. And the business is continuing to operate during that interim period. There could be an additional litigation filed. There could be employees who are hired or terminated. And so the parties will negotiate whether or not the seller is able to update the disclosure schedules with any developments that happen between the signing and the closing. Usually, it can be different from deal to deal whether the seller is permitted. But the key thing to note here is that if the seller is permitted to update the disclosure schedules, then the buyer needs a right to walk away from the deal because there could be material developments that the buyer hadn't agreed to at the time of the signing. And then one other thing to note on the disclosure schedules is that if there is an update, if there is a right to update the schedules, then the seller can only update new information that happens after the signing. It can't go back and say, oh, we forgot to disclose this. It happened 2 years ago or something like that. It just has to be new developments, not any existing misstatements that happened previously.
Let me add two things just on the disclosure schedule before we move on. One is if you're doing cross-border deals, Jenny absolutely described the American practice where it must be on a disclosure schedule. It's not enough that something may have been disclosed in diligence or in conversation. But as I've done cross-border deals, the practice is different in other parts of the world where the view is, hey, it's in the data room, that's good enough. So if you're doing cross-border deals, you've got to educate the people you're working with. And then just to get into the weeds for a moment, when Jenny talks about disclosing something on disclosure schedules, that information may affect 3 or 4 different parts of the agreement. If there's litigation, it's going to go on the litigation schedule, but it may also affect the financial statements. It may be a liability or contingent liability. And so a big part of the effort, certainly of a classic job for a first-year associate, is to make sure the disclosure, the cross-references, the thing hits all the different parts of the disclosure schedules. I'm looking at this question that's come in. I have not done a deal in the Middle East. I'm talking about Europe and Asia. The practice seems to be different. I don't know in the Middle East how they do it, but my experience with working with Asian and European practitioners is their expectation is the data room does it, and that's just not the case in the US. It has to be on the disclosure schedule. Okay. Ben, okay, perfect. Continuity of key employees is a flavor of third-party consents, and Jenny hit third-party consents earlier, but the reason we address it as its own point is it is often, if not the most critical part of a business, one of the most critical parts of the business, which is keeping your employees happy. If you're the buyer of a business, you're really buying, hopefully, a very, very good team of employees, and you want to keep them happy. And generally, right, we keep people happy in their employment role through salary and bonus and stock options and all that compensation stuff. So you need to identify early on who the key employees are, what it's going to take to keep them happy. You don't want to buy a business to find out all the key talent has left. But on the other hand, you don't want to give them such leverage that they can demand excessive payments or hold up a transaction. Again, you don't want to say to somebody, hey, I'm not closing this deal unless you agree to come along. And you can imagine they're going to say, well, terrific. If I'm that important, how much are you going to pay me to stick around? So there's a balance here. But the corollary is you don't want to find out you've closed the deal. And as I say, all the talent has walked out the door. So early on, you want to be discussing employment terms, bonus, equity compensation, and the corollary, the seller wants to make sure the deal actually closes so that she or he can collect the sale proceeds. I think generically among non-lawyers, people hear the sale, the company is going to be sold, and they immediately think layoffs are coming, sometimes for good reason. And an M&A activity is very time consuming. So if you're going to turn to your CFO, if you're the seller, and say to the CFO, in addition to your day job, I need you to help me on this M&A transaction, he or she might say, what's in it for me? And that's this last point about transaction bonuses. So it's critical to keep people happy, critical to identify this early on so there's no surprises. And you got to balance that without getting ahead of yourself or shifting the leverage to the employee. One quick comment to put in your ear, but again, our tax colleagues are going to hit this. There then becomes a negotiation. All of this compensation gets paid through payroll. There's deductions to be had, and there's a negotiation around who gets the benefit of those tax deductions. We're going to leave that tax discussion for the later sessions.
Earnouts. So earnouts refers to an arrangement where the seller's purchase price in the deal is a function of different financial targets being met after the closing. And these earnout provisions can be very complicated and depend on a number of different financial and accounting metrics that the business folks generally negotiate, kind of outside of the legal negotiations. But the important thing here about earnouts is that as the lawyer, we have to basically translate those financial and economic arrangements into the agreement. So when drafting an earnout, when negotiating the earnout, it's always important to work closely with the client and their kind of financial or accounting folks who have put this earnout together and negotiated it. And that way you can make sure that when you're drafting the agreement, it accurately reflects what the actual business deal is. And one kind of way to do that and to make sure everybody's on the same page about the earnout calculations is to include examples. So we like to include in our purchase agreement that example calculations of the earnout are attached as an exhibit. And that way, if there's ever a question about how the purchase price is calculated, then the parties all have the same example calculations that you can look to for reference. And when negotiating the earnout, so the big tension here is that the buyer is buying a business and they're going to want to run it kind of in the way that they they want to in their discretion after the closing. But the seller is going to want to make sure that there's some parameters on the buyer's ability to kind of manipulate the earnout or change the business in a way that negatively affects the purchase price that the seller is getting after the closing. And so we'll go through them in a bit, but that's kind of all what the earnout provision is about, is making sure that the buyer has the right to run the business while the seller is not going to be squeezed out of their purchase price.
I think most M&A lawyers view earnouts as leading to future disputes, or in other words, pushing today's dispute around pricing. We're kicking the can down the street for a later dispute. If we could all agree on the pricing today, we would simply agree a price and move on and not have an earnout. An earnout is a bridge to the valuation, as it says on the slide. Everyone goes into it at a honeymoon stage. Everyone thinks this is going to be easy and the business is going to be a home run. The seller is going to collect all their money. The buyer is going to be delighted to pay all that money. You can imagine, right? So the way this comes up is a seller says, hey, my business is worth X. And the buyer says, yeah, I don't think so. But if it turns out these metrics are hit, then I agree with you that it's worth that much, and I'll pay you then, but prove it to me. And so again, right, as a soundbite up front among business people, that all sounds great, and a seller's confident. One of the reasons a seller is confident is they're saying to themselves, I've always run this business my way, and I know I can hit this out of the park. But things change. Jenny said, ownership changes. The buyer's now running the business, and maybe the world changes, and maybe the projections were just too optimistic. Or maybe you do hit it out of the park, and 2 years on, the buyer just doesn't want to pay. That happens in life, where people just don't want to pay what they owe. And that's why I say it's viewed as just kicking the dispute down the street. And then Jenny's going to run through some of the operational challenges, where it's meant to work right, it's left to the lawyers to try and future-proof for every possible contingency. So Jenny, why don't you hit some of those contingencies?
Sure, yeah. So sometimes there's a negotiation over, whether the buyer has discretion to change the operation of the business after the closing, or if it has to be run in a manner consistent with the way that the seller operated the business prior to the closing. As I mentioned, the buyer is going to want complete discretion to run the business however they want, and the seller is going to be concerned that the buyer can make changes that would affect their earnout. Another one would be whether the buyer has to, use any level of effort to achieve the earnout targets. Do they have to commit a certain number of resources to the business, for example, that the seller thinks would help achieve the earnout targets? Another issue is if there are any add-on acquisitions. So if the buyer's out there acquiring a number of different businesses, does the seller benefit from the add-on acquisition that might boost the financial metrics and the seller's potential earnout, or do those need to be deducted from the calculation? If there's any rules around the buyer allocating overhead of the business to the earnout to the seller's business after the fact, that could also affect the earnout calculation. In some cases, the buyer might have other businesses, and those could be competitive with the target's business. And in those cases, there's always a fight around if the buyer has to direct business to the target, or if they can direct business to the other competing businesses. Which obviously, if they're directing all the business to the competitor down the street, then your client, the target, they're never going to reach their earnout, and so that could be a important consideration. Whether the buyer is permitted to reduce its workforce, which obviously would take resources away from the business after the closing and could affect the revenue targets from being achieved. There's also an interplay if the sellers are staying on with the business and going to be supporting the buyer's business after the closing. Maybe the sellers are able to impact the targets in a way that benefits them because they're still involved in the business. Whether there's any implied duty of good faith or fair dealing on behalf of the buyer, and also whether the buyer has the ability to bundle sales in a way that could affect the earnout. Again, there's all these different ways that the buyer could change its business or manipulate its business, or, kind of change around anything that could affect the earnout provisions. And so, like Scott said, it kind of is the lawyer's job to look for all the different ways that the buyer could potentially impact the earnout differently than what the seller is expecting.
So, and as much as you're hearing us say we don't like them, and I'm speaking for all M&A lawyers and saying they're just litigation to come, given the current state of the market and valuation uncertainty, we're expecting to see many earnouts in the next year or two, as just valuation is unsettled, and for a business person, it's a nice soundbite to bridge that valuation. Okay. So this slide describes very high level the real two alternatives. We've boiled it down. M&A transactions are either done as a purchase of assets or a purchase of stock. I'm oversimplifying a bit. In an asset deal, and we're going to speak non-tax again, there's 3 more sessions to come on all the tax provisions, but a buyer, all things being equal, would prefer to buy assets, and the reason you do that is because you're buying the assets and you are not buying the liabilities. So you like to leave liabilities behind. We had a question about successor liability. So in a well-drafted, well-executed asset deal, the buyer selects only those assets it cares to assume. Classic one being assuming a contract, an important contract, or maybe it assumes a lease. But an asset deal comes with a whole lot of friction. You've got to worry about, are the contracts assignable? You've got to, as a technical matter, terminate all the employees and rehire them at the buyer. You need to have, there's a new EIN in the business, and for many businesses that just presents friction, as I call it. Not that it can't be done, we do asset deals all the time, but it just generates more friction in moving, you're picking up and you're moving the business. In a stock deal, inherent in buying all of the stock, the business that's inside the company remains. So, so first of all, as a seller, again, non-tax, you prefer to package up and hand the whole thing to the buyer. Here's the assets, here's the liabilities, you take it all. And so from the seller's perspective, it allows them to walk away easier. On some of the friction points I mentioned, contracts are not viewed as being assigned. So if there's an anti-assignment provision, there is no assignment in a stock deal. There may be, some of these contracts are better drafted and have change of control provisions. Change of control provision would be tripped up in a stock deal. And then we went through, of course, a number of slides around representations and warranties and indemnification. So as a practical matter, deals get done as stock deals all the time. And as you think about the leaving liabilities behind, the preference in an asset deal, we can effectively accomplish that through the indemnification that Jenny talked us through, and the rep and warranty insurance that Ben talked us through, to get to the same practical result that the buyer is either assuming or not assuming liabilities as he or she chooses. And then for anyone who caught, is wondering what about a merger, right? And I said there's 2 flavors of doing deals, asset deal and stock deal. A merger is just a flavor, a subset of stock deals. You generally, in a stock deal, want to buy 100% of the stock of the company. If it's a small stockholder base, 2, 3, 4 people, that's easy to accomplish. If it's a larger group, maybe you do a merger, and again, what a merger allows you to do is acquire the stock without going to 100% of the people. That's the high level view of M&A, asset versus stock. In a stock deal, you do get successor liability, not even successor liability. You're just stepping into the shoes of the company. The liability continues. In an asset deal, if you've done it right, with a couple of exceptions, you're leaving behind successor liability. The exceptions are income taxes, employment. You can, right, the government doesn't know from, I like to say the government doesn't know from successor liability. So as to third parties, commercial agreements, you're leaving it behind. Sometimes you're stepping into the shoes of some tax liability or employment liability. One thing to note, and again, we're not tax people, we're going to leave that to the future sessions. There are some hybrid transactions. You're going to hear about 338H10. You're going to hear about F reorg, where for us corporate lawyers, it's a stock deal to avoid the friction I mentioned. But for tax purposes, it's an asset deal to get the benefits that an asset deal provides for tax purposes. But again, we're going to let the tax folks speak to that next time around. Okay. Rollover equity in most of the deals we've seen for the last couple of years, particularly where there's private equity buyers, we see almost every deal has rollover equity. And what that means is, as an economic matter, the sellers are selling, say, 75% of the business. They're retaining 25%. As a legal matter, for us lawyers, the sale is a sale of 100% of the target company. The buyer is paying with two currencies. They're paying with cash, and they're paying with equity in the buyer. So distinguish between what I said for the economics and the legal. So the buyer, whatever PE fund it is, now owns 100% of the company, but the sellers are holding 25% 25% of their purchase price in the form of equity in that buyer. It is critical for the tax team to be involved. You want to ensure that rollover equity is received on a tax-deferred basis. It's illiquid equity. You don't want to be paying cash tax on illiquid stock. It certainly adds complexity to the transaction. You're really negotiating a joint venture. Your sellers are now minority stockholders or minority members in an LLC, and you need to think through all of the minority protections. The sellers may want to do some reverse due diligence. They are making, in my example, they're taking 25% of their purchase price, and they're making an investment in this new company. Now, the reason this is exciting and interesting is from the buyer's perspective. They want skin in the game. They want sellers to continue to be invested in the business. They think it drives sellers to work hard. They think it drives the sellers to be more forthright in the sales process, knowing that a chunk of their purchase price is contingent on the future of the business. And selling stockholders are excited for the opportunity to invest in a private equity transaction that most of us can't get into. And in this case, it's a private equity transaction where the seller is saying to himself, I know this business well, because obviously they've run it for the last couple of years. They've owned it. And so they're excited to participate. There's some tax favored way. Again, they weren't taxed on the money up front and then have to invest on a after-tax basis. They're just rolling right over. On the other hand, I mentioned reverse due diligence. You want to understand what it is you're investing in because there's no guarantees in life. This investment may go sour. And then some of the issues, you're a minority holder here. So some of the issues that Jenny mentioned for the earnout apply here as well, meaning you've now put a chunk of your purchase price into an investment that's run by other people. And you need to understand what the cap table looks like. You need to understand if that PE fund is charging a management fee or is otherwise taking money out of the business non-pro rata. For us lawyers, we need to review the equity documents. Oftentimes, there's a non-compete in the equity documents, so that so long as you're a member of this LLC, so long as you have equity in the buyer, you won't compete. Well, in the M&A transaction, maybe you negotiated for a 3 or 4, maybe a 5-year non-compete. Here, you're potentially inadvertently signing up for a perpetual non-compete. So long as you hold this equity, you won't compete. And most often, you don't have a put right or any ability to get out of this equity. You're beholden to the PE fund for whenever they may sell this investment. So at a minimum, you need to know what it is you're getting into. There's forfeiture provisions potentially, repurchase rights potentially, and you want to give thought to some minority protections, board seats, veto rights. I put all that with an asterisk because if you're a 2 or 3% holder of the buyer, you're unlikely to get those sorts of things. If you're a larger investor, maybe you get them, but the point is you're really negotiating a joint venture arrangement, just like any other joint venture arrangement. And you got to do it knowingly. One other comment, sometimes, and Jenny and I have done one or two deals where the buyer is a public company. We don't mean to turn this into a securities law class, but just because the buyer is a public company, just because you're getting stock in a public company, does not mean that you can go off and sell it in the market. Private placements, even of public company stock, result in restricted stock in your hands. For this group, it's just enough to say, to ask the question, how is it that I'm going to be able to sell this stock in the future? Can I sell it immediately? More often than not, the answer is going to be no, and you'll want to give thought to how it is you can turn that stock into cash.
So our deals are typically or the purchase price for these deals are typically determined based on the seller delivering the business on a cash-free, debt-free basis, and also with a normalized level of working capital. But because working capital can fluctuate over time, and the business will stop on the day of closing to make sure it has the normal level of working capital, there's a purchase price adjustment process that happens in all of these deals. So what the parties do is they'll agree on it, what they think is the normal level of working capital, and that's the target working capital. And then after the deal closes, there's a process in the agreement that says the parties will look back at what the working capital actually was at the closing. And if the working capital of the business that was delivered to the buyer is higher than the target, then the seller will get an increase in the purchase price for that difference between what was actually delivered and the target. And if the business is delivered with a working capital level that's lower than the target, then the purchase price will be decreased. Because we're running short on time, I'll go quickly, but just know that there can also be similar adjustments to the cash that's delivered at closing, the debt that's delivered at closing, any transaction expenses as well. And the key point here is to make sure there's a robust dispute resolution mechanism in the purchase agreement, because these can be quite complicated calculations, and there can be disagreements between the calculation of the working capital at the closing and following the closing. So you want to make sure that there's a process set forth in the agreement for any disputes that can come up. And the parties may also decide to put some money in escrow to cover any decreases in the purchase price that would go back to the buyer. There could also be a cap on any purchase price adjustments, but those are more rare. Usually we'll just see an escrow.
I'm going to hit the next couple of slides just to go back to the specialty areas, but I'm going to hit this one and the next one I've got my eye on the clock. So here, hopefully you've come to understand, if you didn't already, that M&A is its own specialty, and this slide hits some of the other participants who are key to be on an M&A team. We call it a team sport, but I think that's all I'm going to say on that slide. And then let me just hit a couple of other things. So two things to keep in mind for the group that until recently, the M&A bar didn't give any thought to. One is who owns the attorney-client privilege. All the conversations that I have with my clients on the sell side, I think everyone's expectation is those are to remain between me and the sellers. But this case, Great Hill, without getting into it, said that those privileges, in the absence of some other contractual provision, would go to the buyer. That was a surprise to the community. The point is, at the moment, every deal now, in reaction to that case, every deal now says that the attorney-client privilege of the negotiations of the transaction stays with the seller. And when I say seller, I mean the principals of the seller. So that does not go to the buyer. And similarly, because the expectation, if there's a post-closing dispute, that my client, I mean the people, the humans, are going to call me up and we're going to help them on any dispute. Every M&A deal these days includes a conflict waiver to allow for that. So to know on those 2 points is make sure the agreements address attorney-client privilege, conflict waiver, and then another inside tip, if you're not aware, there are 2 great surveys that cover much of what we've just gone through. They serve as a market check for M&A practitioners. SRS Acquium puts out a survey. The ABA puts out a survey on deal terms. Again, much of what me, Jenny, and Ben just went through is all covered in these surveys. Not that you sit at an M&A table with the survey in hand, but it's just a good market check, as I say. So I think with that, again, with my eye on the clock, we're just going to say thank you for paying attention. We hope it was informative, and we also thank the Beverly Hills Bar for the opportunity to do this webinar. So thank you.
Thank you, Scott, and Jenny, and Ben. Be sure to sign up for our next part of this series on November 14th on the tax aspects that Scott and Jenny and Ben mentioned a few times in the past in this webinar. And with that, have a good day.
Again, thank you, everyone.